Greetings. So this lecture, we're going to work through an actual ALTA NSPS Land Title Survey and look at some other examples. The whole goal is to introduce everybody to the aspects that are needed to be able to add on to your boundary surveying skill sets and uh, produce an ALTA NSPS Land Title Survey. Now we've got like 3 hours worth of lectures and lots of pages of material on what an ALTA NSPS Land Title Survey is, and we're just going to call that ALTA from here on out. That's an industry term. Um, what makes it different than a state standards survey? We'll briefly touch on those differences here for the purpose of professional practice in preparing a ALTA survey. So um, at this point, I want to share my left screen over here. And what we're looking at is a title commitment. Now, we've also just had a lecture and a full explanation on title commitments, but this is one of an actual piece of property that we surveyed, did an ALTA survey on. It's been 5 years ago now. It's a nice example. It's not too complicated. It's not too simple. And you'll see what I mean by the time we get through with this lecture. But we just have our basic First American Title Insurance Company ALTA commitment for title insurance, commitment number, blah, blah, blah. Here's the conditions and all. This is just boilerplate. You can tell by looking at it. There's nothing particular in it, kind of like the ones that Callaway Title and Escrow. Turns out a lot of it is not boilerplate. But here we are in Schedule A. Okay, the kind of know what this tells us is, okay, the primary certification name is probably going to be Zach Properties LLC, and the lender that we're going to list is going to be Atlantic Capital Bank, NA, and we're going to list as First American Title Insurance Company because they are up here. It's theirs. So, not being critical, but so number three, they're saying this is fee simple. That's good to know. That's what Schedule A3 is supposed to do. And Schedule A4 is supposed to tell us who the title holder is, and they tell us that it's Danny R. Moss and Charlotte L. Moss as of September 15th, 2020, the date of the commitment, which is when the record was examined, not the date that they prepared this title commitment. It would have been nice if they had included the vesting deed, just as a confirmation that what we have found independently through our research is the same. And Schedule A5, the land is described as See Exhibit A. So for the purposes of brevity, I will tell you that in our research, we've gone over here, we've pulled this deed book 21076, page 162, as from that's what Q Public said the current title, the current vesting deed is. We pulled that. We went on GSCCA and ran a grantor on that entity in that deed to see who it was or see if they had sold it, and they have not. So I'll share with you that this is the vesting legal description. Now, normally that's going to be the same as the insured legal description, but never take that for granted. Everything in surveying should be challenged and proven to your satisfaction before you put your stamp on it. I have saw some really wonky vesting descriptions that were used in a security deed 3 conveyances ago that had hair on it, and I have no idea why they wanted to use it, but it was different than the vesting description, which was not only more legally relevant, but it was a better legal description. So don't take it for granted. That's why I'm telling you, I went and checked. So we didn't find any of those issues here. So I think at this point, I'm going to pull out the title commitment and look at it. I'm just going to go ahead and cut to the end of the story. This is the guts of the survey that we prepared. And I'm going to pull back over into the screen. this other PDF with commitment. So it says, let me do this. This is very important. A lot of folks have been struggling with this in the assignments. Um, the point of commencement is very important. It's what nails down the piece of property as to where it is on the face of the earth. Otherwise, you could have a bunch of pins that are the right distance and bearing from each other that are in the totally wrong place, and nobody'd ever know it until they started building over the line or a dispute broke out. That's why Georgia standards, ALTA standards, all good survey standards require a good point of beginning, point of reference, point of commencement. And so that's where you start. You don't have to start there, but you have to at least confirm it by the time you're done. And then that's where your legal description does start. So over here, well, let's go look over here in Exhibit A. To find the true point of beginning, commence at the intersection of the southerly right-of-way of Hembry Road, 60-foot right-of-way, formerly Old Roswell Road, with the common line between land lots 650 and 691. So that's what we need to do. So what we did, we went up and we found D-Book 21076. We found, these adjacent owners. We went out there. We found and confirmed this rebar right here, which is at the intersection of the land lot line and the southern right-of-way. Now, we should have probably labeled this as POC, but it's the POC regardless. So this is a little bit of boundary resolution going on. This is based on, when you skip down to the bottom, based on the 1998 survey by Brumbelow Reese. It was not recorded. That's okay. But so from this point of beginning, run south 005226 east, which we're pretty close to, 157.74 feet to an iron pin found, and the true point of beginning. So the people that drew up this legal description used the old convention of verbiage where the point of commencement is the point of beginning, and then the actual point of beginning is called the true point of beginning. Anyway, you follow along and it makes sense. I'm not big on that stylistic, but here we got measured 157.90, record 157.74. That's 1600ths. That's 2 inches. We're there. So now we are at the point of beginning. Thence from true point of beginning, run north 89.55.34 east, 236.20 feet to an iron pin set by Rodney Reese on the westerly right-of-way of Maxwell Road. Being a 60-foot right-of-way, also being 159 feet southerly from the intersection formed by the westerly right-of-way of Maxwell Road and the southerly right-of-way of Hembry Road. So we're 159 feet down from the right-of-way intersection. Just keep that in mind. Also notice that what Jeff did when he prepared this survey is he rotated our coordinate file to match this line's bearing. So this line, please look at this, and this will be in your material, is the bearing basis. This is where we rotated. This is where we got our meridian is set on this 1 1/4 inch open top found on the land lot line to the 1/2 inch rebar found on the right of way, being north 89.55.34 east, which is right here, the first line in our legal description. So then we come down the right of way 177 feet. 177 is what we found because we set one. We did not find one there. Thence run south 89.44.59, 250.40. Did not find or found a 1 inch open top pipe back here, which would be iron pin found. And thence we go north 0053. So our bearing should be within 2 to 5 minutes of the same, depending on the positional tolerances of this 1998 survey. 177 feet, we come up with 176.93. Now, in case you didn't pick up on it, Jeff computed this iron pin set right here by going distance. So we're holding the record distance down the road, holding the record distance back, both from iron pins that were found and confirmed as good, reliable monuments. So that's how this corner was set up. I can also tell you that Gronholm, that owns to the south of us in D-Book 27583, he's got a pin down here 300 something feet from the right-of-way intersection, and it was not found. So Just keep that in the back of your mind for the moment. So our boundary looks good. Um, excuse me. Um, our boundary looks like the vesting deed, looks like the title policy's insured description. So that's great. We're getting there. Uh, Schedule B1 requirements. Again, this usually doesn't pertain to us, but it's worth looking for or looking at. Fulton County taxes are due and payable, which they weren't past due or anything. They're just letting everybody know the status of the taxes. And then we get to Schedule B2, the exceptions. And basically standard exceptions 1 through 7. That's all basically boilerplate stuff that you'll find anywhere. Then we get to what we will call in the industry special exceptions. In other words, they are special or unique to this particular piece of property. So there is a sewer easement dated 1986 in Deed Book 9963, page 33. And there is a boundary line agreement in 1983 between Turner and Field in 8702, page 248. Now let's look and see if there's a exception 10, and there's not. And we know that because if you look here at the bottom, it's page 2 of 2. So if it was 2 of 3, that would be a red flag that we missed something. Now, this was done under the 2016 ALTA standards. 2021s had not come out yet, but that's really not relevant. So what do we do? So we've got 2 special exceptions. ALTA requires us to comment on those. So here's how we do that. Survey matters pertaining to First American Title Insurance policy, blah, 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 Schedule B, Part 2 exceptions. We don't list the 1 through 7. We don't comment on those. They are standard exceptions. The only ones that we consider to be in our jurisdiction, our realm, are 8 and 9. So before we get there to his answer or to his how he summarized it, let's look at them. So 9963, page 33 is right here. Maxwell Road Sewer Extension, name of the project, handwritten sewer easement, or at least some of it's handwritten. Obviously, it's a form. Land lot 691, First District, Second Section, Fulton County, Georgia. That is very important because there are a lot of vague and ambiguous descriptions and even exhibits that sometimes it's very difficult to tell where they are. So making sure that they are in your land lot is the first thing, or in your GMD if you're in the coastal area. So what it is, it's a 35-foot temporary easement reverting to 20-foot permanent easement, with the remainder of the 15 being temporary to the construction or to the completion of construction according to excerpt plat attached of plans on file in Fulton County Planning and Community Development, approximately 177 linear feet. Special provisions. Number 1, the party to the second part, which is Fulton County, will replace all soil removed and pay any damage to crops. So this is obviously a very old form easement. Number 2, which is handwritten and specific to this property, is the manhole is to be as close as possible to the northern property line and installed flush with ground level. Well, that really is not relevant to us either. All we know right now is it's 35-foot temporary and 20-foot permanent, and this was allegedly done in 1986, so unless we see fresh dirt like it was just placed, we're going to consider it done and ignore the temporary side of it. And then here, bingo, bingo. This is us. This is an excerpt of their plans. And if you can see where my cursor is, if you're on a good size screen, this is us right here. Turner is just who owned the property at that time. So up here's Hembry Road. We're coming down Maxwell Road. You get down here to our property line. Here's where a manhole is going. Sewer is considering to just carry on. You got to look at the dimensions. It's 20-foot permanent, snowed right up to the Maxwell Road right-of-way line. And then the extra 15 feet is over here inside our property, a total of 25 feet from the center line of the sewer line. Why is it only on one side? Because the street right away is on the other side. So, um, seems easy peasy to me. We know that it's 20 feet snowed up to the right of way of Maxwell Road. And here is Maxwell Road. And here's where Jeff has drawn the sewer easement. Now, one thing that is worth mentioning is apparently plans changed after they got the easement. That is not uncommon. They put the manhole instead of up here near the north property line, although there is one up there. There was just one shown in our property, one up here closer to the, pretty close to the northern property line, which is not far off from where they probably got it. But then the next one was supposed to be south of our boundary on somebody else's property, but there is another one, which we pull. You have to pull these manhole lids. ALTA surveys don't require inverts and pipe sizes, but you got to show storm drainage and sanitary sewer lines. So you have at least got to pop the lids, get a direction. Sometimes you have to shine flashlights. Sometimes you have to be creative. That's all field practice. But we popped the lids. We saw this service line coming from the warehouse. We see it coming down here, and wow, here's a manhole. Pop the lid. It's going across the street. And I believe they said they could see the manhole on down the road on the other side of the street, or maybe it was in the street, but it does not continue on south. However, the easement that was granted is not relevant to where the sewer wound up being located. This easement was prepared, executed, recorded, and became legally binding before the sewer line was installed. So the sewer line location has nothing to do with the easement location other than it's supposed to be in the right place. So snowed up 20 feet from the property line all the way down is a 20-foot sewer easement. And we're showing that sewer line easement as best we can, veering off and leaving the property. So that's one thing that we've done there. Special exception 9 is a boundary line agreement, indeed book 8702, page 248. And here, Ray Turner was the grantor. Of course, with the boundary line agreement, both parties are grantors, both parties are grantees, but they have to set one out as grantor and grantee in their fancy form letter. Now, this is obviously before computers, because you can tell they've got a blank boundary line agreement piece of paper that they copied back in 1983, and they have just filled in the blanks with a typewriter. You can tell it's even a different font. Um, Boundary line agreements, we won't dwell on too much. We studied those last semester. Um, Basically, what they're doing is saying the boundary line is more particularly described on the attached plat. Perkel and Isaacson made Exhibit A is the boundary line that they are agreeing to. It says, whereas there is a question as to the exact location of the boundary line between the grantor and the grantees, the parties hereto are desirous of definitely establishing and locating the boundary line between their respective properties. Now, consideration of $10, blah, blah, blah. They forever quit claim and release unto each other any land on the opposite side of this line, which shall be forevermore hereby known as the property line. So, the only disappointment is they didn't stick the plat in as Exhibit A. They crafted a long legal description of that 1983 survey as Exhibit A. So, we're going to move it over, minimize it a little bit. Whoops, let's come back to this property. And if you remember, this pin's supposed to be 159 feet, and then we're 177. 159 plus 177. It's important because to understand where this boundary line agreement is, we have to go back to last semester and interpret this legal description. So it says, find the true point of beginning, commence at the intersection of Old Roswell Road with Maxwell Road. That's running southeasterly along the right-of-way, 336 feet to an iron pin found at that time, and the true point of beginning. Same stylistic. So remember, ours is 159. Our northeast corner is 159 from Hembry Road. We got another 177, 177 plus, or 159 is 336. So what's that telling us? The true point of beginning of the neighbor's property and where this boundary line agreement starts is our southeastern corner right here, where we set the pin. Then it goes south down the road, 152.8. Then it goes west back to the landlot line, 264.4. Then it goes north, 186 to an iron pin found. And then it goes north, 89.45 east on the property line of Turner, 250.4 to an iron pin and the point of beginning. 250.4. This is us. And again, the party that owns this now is Gronholm, and their pins below had been knocked out because I believe there's been some property combined down there. But we have established that we're the right place down the road, the 336. So we're here, and you know, we built in some poly lines, slid them together, make sure everything fit, looked good down the road, looked good with the distance up to the Hembry Road. We got the line in the right place. We're confident enough we're going to stamp it and say that we did. And so that is special exception 9, which is the boundary line agreement. So now let's look at this a minute. Here's how we do things a little different on an ALTA survey, because we are required to relate everything back to the title commitment. So Jeff has dimension this 20 feet, and his notation is described as a 20-foot sewer easement in deed book 9963, page 33. Here's where it gets different. Typically we put in parentheses. There's all kinds of different ways. You don't really have to, but you have to relate it to the title commitment. So we just simply call it exception 8. Maybe it would have been exception F, might have been exception 22. But in this particular case, with this particular title commitment, it is exception number 8. The other one is the boundary line agreement. In other words, they have found these documents that affect the property in the title search. And so they are of record. They can't go back and change them or fix them. So they are exceptions from coverage. If anything comes up from this, it's not covered. So they want to make sure that we account for all of these special exceptions, tell them where they are, point it out to them, and we either hope that it's all good and everybody likes it, or we may reveal some problems. I think one of the examples, I had several examples, and for the sake of time and brevity, I took some out. But one example that I've got down on Cobb Parkway has an old telephone easement running through a car dealership, or running underneath it. Now, they moved the telephone line. It's been relocated, but the easement is still under the building. So they're very concerned that, Bell South could come back in and want to lay a phone line, or bury a phone or a fiber optic cable through the middle of their showroom, because they have an easement to do so. It encumbers the property. Anyway, these title commitments, I'm being redundant. That was the last lecture on title commitments. They point out these 2 exceptions that are survey matters that can be located and plotted. Now, a lot of them are going to be blanket. It just is going to not tell you where it is. It's going to say the property of Ray Turner, lying on the west side of Maxwell Road. We didn't have that in this case, but that would be typical. And then we would just address that by saying that power line easement in deed book 999 is blanket in nature and cannot be plotted. You can go back to the ALTA specs and review the part about the drafting of the plat, where they tell us how they want us to address those. So, this is how we did it. Boundary line agreement in 8702 pertains to this property line. It is exception 9. So the attorneys looked at this plat. They said, oh, there's where exception 8 is. Beautiful. Doesn't cut us off from anything. Doesn't hurt anything. We got a sign sticking out in it, but here's the sewer line, so we're probably okay. Maybe they're not worried about some damage to the sign if they have to tear up the sewer line, but it doesn't go under the building. It doesn't cut them off from anything else, so they're good there. The boundary line agreement, great. So we've got it where the boundary line agreement goes, so it's not going to come back later and bite us in the butt. That's wonderful. That's what they want to know. And then here is the note. I was getting ahead of myself earlier, but we just list number 8 and we describe it. Sewer easement in 9963 lies within the subject property as shown. You could say along the eastern boundary of subject property. There's lots of ways you can describe it. You just need to explain to the attorney this is where number 8 is, or I don't know where number 8 is. Or if you figure out that the same guy owned two pieces of property and one's up in land lot 650 or 640, you can say it lies in 640 and does not affect the subject property. You just have to muddle your way through it and do the best you can. Number 9 is a boundary line agreement. 8702 describes the southern property line of the subject property as shown. So this is a very well worded note that explains to everybody exactly what it is. It describes the southern property line of the subject property as shown. So you don't have to go figure out anything else or read between the lines. We're just telling them that's where it is. Here is the ALTA NSPS certification that's used verbatim. This is a 2016 standard, but you've got all these properties that need, or all these entities that need to be in here. Zach Properties LLC, they're buying it. First American Title Insurance Company, they're insuring it. Atlantic Capital Bank NA, they're lending on it. We just looked at that. Danny R. Moss and Charlotte L. Moss, they wanted to be on it, or they wanted them to be on it, probably because I think they are lenders. They are probably doing some owner financing, because not only is there a bank, but you have this lending intermediary, Small Business Access Partners, Inc., which facilitate U.S. Small Business Administration loans. U.S., the SBA. You hear about an SBA loan. So they have loans that are more conducive to businesses, small businesses, more so than large corporations. And so sometimes you wind up with a lot of different people. Basically, everybody that's participating in the loan or affected by it is going to want to be certified in here, so that if there is a problem with the survey and it causes a problem, and let's say that the bank bows out and the Mosses that owner financed it wind up holding the bag, then they've got somebody to sue. That's, there's a lot of data that's available now, aerial photographs, online deeds, tax maps that people think are gospel, etc. I jokingly asked a friend of mine, Kyle Levsteck, title examiner that joined us last semester with Callaway Title. I said, before long, you're not going to need a survey. And he said, nope, you're wrong. Always going to need a survey. I said, I hope so. That's my business. And he said, always going to have a survey. I said, why? He said, we need somebody to sue if there's a problem. So don't take these ALTA surveys lightly. I'll show you, this is something that I do. I've gone through the ALTA standards, and we address various aspects that we want to elaborate and have our elaboration on the record. Some of this changed with the 2021 standards, but this is just boilerplate for us. We stick it on every ALTA survey. If there was a case where we could not comply with the measurements and the precision that's required, we would stick it on here. But this is where we kind of do a boilerplate laundry list things, which, even if you don't have a riparian or water boundary, the ALTA survey still says that we're supposed to include this statement. So we just include it on all of them, just to be on the safe side. We've also, let's see, this is our data. This is a recording box. Notes pertaining to Table A items. These are the Table A items that they requested. And this is, again, the 2016. They requested item 11, which is utilities, but we did not do utility locations, so we elaborated on that. They wanted an as surveyed property description, which we also provided in Word format, but here it is. And let's see, what else bears witness? Oh yeah, down here where this retaining wall, or where the boundary line agreement is on the southern boundary line, this retaining wall is within 5 feet of the property line. ALTA standards require us to show anything within 5 feet of the property line. So that retaining wall was within 5 feet of the property line. Our crew picked it up, added it to the plat. This power pole up here is technically off the property, but it's within 5 feet of the property line. It's right at it. Might even be a little bit more. If it's close enough, we're showing it. Got the acreage. Vicinity map, which is not required in Georgia, is required by ALTA. And then this is ALTA NSPS Land Title Survey. Their standards require us to put that in the title block. That has to be the caption. Now, we still have to do the Georgia Surveyor certification. If you remember the Plat Act, it says that we can have other certifications like the ALTA certification, but we still have to add the Georgia certification on there. And this is a retracement, so we used we use certification 3. And here we have different clients with different tastes. We don't argue about stuff that doesn't really matter. Normally, all we would put in here is prepared for Zach Properties LLC and leave all these other people off the title block. This particular lender, or excuse me, their counsel wanted to see everybody's name up there. They didn't really understand that this ALTA certification with the exact verbiage, this is where it has to be. This is where the certification is made, and putting everybody's name up here in the title block doesn't really change anything or make it any better, but it doesn't hurt anything. So we just did it. We appeased the client. Yay, there we go. So this was a good example of how we, to work through how we prepare an ALTA survey. So I want to look at 4 more ALTA surveys, but not in that level of depth. So we're going to look now at this survey, which I did in 2023, and the client actually wanted it recorded, Cobb County. That's beautiful. It's at the intersection of Cobb Parkway and Wiley Road. I just wanted to point out a couple of things. We've got this fence. We don't know whose fence it is. It starts on our property and goes to theirs, or maybe it starts on theirs and comes on to ours. But I can tell you that even though this is not maintained yard, there's some pine straw and stuff. The people that occupy this property, basically, it's implied that this fence is their line. So that's why we went ahead and showed that fence beyond 5 feet from the property line is, yes, people, there's the fence, and you can get a scale. If you want to plot this at full scale, this is 1 inch equals 30 feet, which is found on every engineer's scale as required by the Plat Act. And you can scale and see how far from the property line that fence is if you want to, or we could go through there and show them how far north it was every few feet. But that's one thing to point out. Another thing that's a real big serious issue with title folks is this big culvert that comes under the parking lot and ties into this big culvert that comes under Cobb Parkway. There is no drainage easement on record. There is no mention of that being there. Basically, this property was probably developed many years ago before people thought about drainage easements and things, and there was a ditch that ran through the property. And when they built this 1-story stucco building, which is like Atlanta Exotic Cars LLC, I think is who occupies this property. When they built the building and the car lot, they just piped the ditch and covered it up. The title ramification or implication is that that head wall up there and that concrete flume, which extends north of the line a couple of feet, that receives Willett's property, that receives stormwater from Willett's property. So we're basically responsible for it. So there's some title implications. Even though there's not a formal drainage easement, there's sort of an implied drainage easement. And my friend Kyle Lister uses this example. If you cut this off or stopped this up and you flooded Willett, you would have a problem. And it would wind up being real estate law. The rite of passage of stormwaters or intentional impairment of a stormwater conveyance structure. The lawyers could get creative with that. But that's the reason why we show that. Their parking lot is right up next to the property line. It's within 5 feet. That's why it is shown. There weren't very many things on the title commitment. There weren't very many exceptions. We do point out we've got an encroachment right here. Some of y'all missed a similar driveway encroachment on the DeKalb County Module 10 example. or assignment. And here, our shots on the dumpster pad, dang, it's a half a foot north of the property line. So we have to point that out. Apparent location of 30-foot sewer easement in deed book 353, page 179, exception C, C note. So let's see that. Sorry. So here is our statement on all the notes. Sewer easement, and I'm going to see in deed book 353. Now I'll go ahead and tell you that's like in the late 1940s, early 1950s. That is a low numbered deed book in Cobb County. It's just described as being 308 feet in length, bounded on one end by Wally Road, and 30 feet in width. A non-specific reference is made to plans which were not included. The location is otherwise not described and cannot be plotted with certainty, but is assumed to be centered on the sewer line which traverses the property as shown. In other words, they found this sewer easement. It says it's 308 feet of sewer easement. It's 30 feet in width, and it's Wally Road on one end. And there is one, and you can confirm it with Cobb's GIS, there's one sewer easement anywhere near here, and there's one major sewer trunk line, and this is it. And here it is. Wiley Road used to probably be a little bit narrower and might have been a little bit further south. 308 feet is not a bad estimate from one end of the property to the other, but we can't really say for sure. That's why we have qualifying language in that note. It could be on the south side of Wiley Road. It could even be somewhere else on Wiley Road. We just know that it's approximately 308 feet in length, and it ends or starts at Wiley Road, and it's 30 feet wide. So what we've done there is just explained that very situation as best we could, and it's basically all we can do. We also have the city limits over here, and this little area, this part of Wiley Road's in Cobb County. Our property is in the city of Marietta, and that city limits goes crazy from there based on the GIS maps. That's why I didn't show it, but where it was relevant and where we did know that it was, where we did know that where it was, we've shown it. So that's another ALTA survey. We've also pointed out, got a few other little details. We've shown all the light poles, all the improvements. We pointed out that the curb is inside the right of way up to 9/10 of a foot. So their curb is encroaching on the right of way a little bit. Here it's over the right of way 1.4 feet. Yikes. And over here, what we're explaining is that exception E is showing the right of way to be 25 feet wide and in this location. So we're just noting that. And if we want to come down and look at exception E, we're explaining that the right-of-way deed in 356 calls for 50 feet width, 20 feet on each center line, as depicted on plat book 14, page 102. And that's basically how that old plat shows it. I think that was an old hand-drawn plat, maybe from the 50s. There are these other exceptions that we won't go through. Well, we won't plot all of them. Let's look at it. Here's a sewer easement that's described as 492.3 feet in length. We just don't know where that one is. That may have been a different piece of property, but with it being 492 feet, it doesn't really fit anything on our property. And there's another sewer easement. And it says it's running between two county roads, 145 feet in length. So that's probably not ours either. And all we're doing there is we're just explaining, hey, the location is otherwise not described and cannot be plotted. We're not saying that it doesn't affect the property. We're not saying that it's not on our property. It may be, it may not be. We're just saying it cannot be plotted. And attorneys may push you to try to take that off. Tell us, does it affect or not? Well, that's a legal opinion. I'm not an attorney. I'm a surveyor. I can tell you where it is, or I can tell you that I don't know where it is. But the legal implications are yours, Mr. Attorney. Sometimes you have to feel one. Be kind of strong. We looked at D. Actually, D's a prime example. It states to be located in land lot 644, and therefore presumably doesn't affect the subject property. So we can throw that one out. We're not worried about it. It's not even our same land lot. Probably the same owner, and they probably just added it to be on the safe side. I've worked with people who everything in the book they put in there. I saw like 60 title exceptions or special exceptions before. Had to go through all of them. There was like 8 that actually affected the property. The rest of them were nowhere near it. Sometimes they were on the property next door. Sometimes they were up the road. Sometimes they were on the other side of the county that the same person owned back in 1965 or something. Um, G, here's a prime example. Well, here's another one. It also says it's in land lot 644. The other one says 643. No, excuse me, 644. Then we come out here at Georgia Power, 644, 643. H is an electrical distribution line. It's depicted as being at 991 Wiley Road, which is a development on the east side of Wiley Road and along Wiley Circle, which lies north of subject property, and therefore presumably doesn't affect subject property. I use the word presumably because I don't want to be making a legal statement. Sometimes I will. It just kind of depends on the circumstances. There's a driveway easement to the city of Marietta recorded, but it does not contain Exhibit A, which purports to depict the location of said easement. Therefore, it cannot be plotted. Don't know where the driveway easement is because they did not record the Exhibit A. So, there we are again without much to go by. Now, we'll look next to the piece of property. This is in downtown Atlanta. This is on Piedmont Avenue. You saw this building. It's right there around Georgia State University. You can see it, I-75, 85, the connector is just right like over here, not too far from the north arrow. It's about an 8 or 12 story building. It was the Oxford building for the Oxford company. Now it's Cristo Rey Jesuit High School. And they put in pools and tennis courts and the parking deck and everything. It's really cool. But the reason I wanted to show this is, one, there's no title exceptions. Title commitment number 2914.1-0 includes no exceptions, which are survey matters. They've got the standard exceptions, but no survey exceptions. Now, the reason is a lot of times in cities like this, especially the city of Atlanta, their right-of-ways are wide enough and everything that they need is in there. As a matter of fact, there is a electrical substation, which you might normally see on a pretty good size, 100 by 100 out in the country. There is a full-blown multi-level electrical substation underneath Piedmont Avenue right here in front of this building. Because a lot of these buildings, they pull as much power as a small community that gets a substation with the power company. But it's all out in the street right away. Here we've noted that John Portman Boulevard's what it was renamed a few years ago, but on all the old plats and deeds and stuff, it was Harris Street. I don't know why they changed the name, but we discovered that, and we're hoping that we're passing that along for the title folks to understand that if they saw something for Harris Street, that's the same thing as John Portman Boulevard. But there are no easements, no cross collateral agreements or anything that affects this property. There is a state-owned parking deck next door, which according to their own recorded survey here in Plat Book 152, page 12, we matched up to it. Everything fit within hundredths, like you would hope that it would. But they've got a wall and a handrail that's up to 4,200 north of the property line. So the state's own survey is basically confirming that we have a little encroachment. And down here, we're saying that the wall and the handrail is 1/10 of a foot south of the property line. So we're telling them it's clear on that end, but it's over by 4,200, which is about 5 inches on the other end. So, and I'm also noting that the parapet and handrail is elevated above the surface over the subject property. It's about 4 stories, maybe 3 stories above our parking decks, where 2 parking decks basically touch each other, and one leans out a little bit more over our property. So it's basically a potential encroachment. I'm not calling it an encroachment. Don't know who authorized what, but we put it there. We've got the as surveyed legal description, the standard ALTA notes, the vicinity map. This is our old format, and this fell under the 2011 ALTA standards. Again, just pointing out that in this urban properties high rise, this is not really a high rise, but it's a large multi-story building. The measurements have to be pretty tight. It gets pretty pretty squirrely, pretty hairy. I forgot to point out earlier, but we show the dimensions from the property line to the building corner to the closest building corners. That is a requirement. I normally just do it to the nearest tenth of a foot, but this was a very high precision survey. We did a lot of double angles and a whole lot of really tight total station work on this. It was a 100% total station job with 2 or 3 men, myself included. And so we stated the distance to the property line to the nearest 100. Also, they were needing this for City of Atlanta plans to renovate, and I believe they wanted it to the 100th. So if you measure that tight, you might as well state it that tight. But again, this is an example of an ALTA survey that, even though it is a piece of property like that, I don't know, $30 million ballpark, no survey exception, title matters. Pretty amazing, in my opinion. Next is one in sort of South Fulton. It's Hapeville. It's not far from the Atlanta airport, right off the 75 and near Porsche Boulevard. And I wanted to point this one out. Again, only that first one we're going to go through everything. But here, just to kind of emphasize a few things. This up here, Dogwood Drive, formerly Stewart Avenue. Our record point of commencement, our historical right-of-way intersection is up here. And they've redone the sidewalk and I don't know what all, but we've come up here and confirmed this is the record point of commencement. And now we're coming down 294.6 feet to a nail and washer set that is 4/10 of a foot west of a bent nail found. Now, I don't like setting corners near other corners, but this all was so tight that the margin of error tightens down. Board standards say 2500ths, but we're in an urban environment where it's a tenth. So 4/10 was not within our measurement standards. And we had enough stuff to nail down where the position ought to be really tight and to hold that nail, put a 4/10 kink in the property, and it would have made this face of the building over the property line. And we know from some of our research that the full intention was that this face of the building was to be the property line. And so it worked out with the record point of commencement and the face of the building. So we set a mag nail and washer there in the sidewalk at the property corner. And again, there's some stuff that if you go back in the research, we set a pin 3.14 feet from it, and there's another pin 4/10 of a foot northwest. I see here it was southeast. Here's northwest. So the rebar we found in the back is the opposite direction off the property line as the nail that we found down on the sidewalk. So that also further discredited our boundary resolution idea that we would want to hold those. As we progress through the most defensible solution, we would like to use the pins that we found, but one is 4/10 of a foot in one direction, one kind of discredits it 4/10 in the other direction. Now you've got nearly a foot of uncertainty in an area where all the rear adjoiners, we nailed them down, made sure that we were on their line and that we weren't off a pin or two. So when you're on a common line like this, you've got to do enough surveying up and down the line to confirm your side of the line and their side of the line. And again, we had to set all the pins out there. I didn't like it, but the other thing to point out is that going back over 100 years, these walls were the property lines. And you've got brick that's older than my grandfather was, older than when my grandfather was born. This building hasn't gone anywhere. That's probably the best monument out there. And somebody just got sloppy and set some pins a half a foot in the wrong place. They probably built in an ASCII file, went out there and took a 37-foot backside on something and started setting pins 200 feet away. Just some dumb rookie mistake, and threw some monuments in the ground that unfortunately had to be discarded. So that's part of what I wanted to talk about here, the importance of the point of commencement. Here's some of the legal descriptions also called out, being known as 637 North Central Avenue. So the street address we observed the street address on each building and added it in. And there's some easement magic going on. So, our lot is 37.2 feet wide. It goes wall to wall. You can't get to the back of it with a vehicle. So they have gone in and have these utility easements and access easements that we had to build in and plot and situate on the ground. They have measurements, point of beginning, point of commencement, that tell us where they are. And so we had to use those to set those up. There are, a few of them, exception number 6, exception number 9, exception number, looks like we left that blank. That's a mistake on our part. But you've got this deed book 2672 that's got a 10-foot alley. You got another one that shows a 10-foot alley. This is basically saying that these people next door, Mustafa, they have a right to come up this parking lot and cross our property 10.3 feet wide to get into their property. That's probably a delivery door. It's probably a restaurant or a flower shop, and that's how they get deliveries. Although this other easement goes all the way up to the back property line and cuts across to serve them. So we both benefit by these easements and are burdened by these easements, which is pretty neat stuff. Now, we're nearly done. I'm not going to dwell on the next one because I could dwell on it for a long, long time, but I just want you to take a look at this one. I surveyed, did the field work myself, or at least part of it. I was out there a couple of days or a couple of times last September. Well, we did it actually in March, and then we went and sort of redid it. They added some stuff, wanted to redo some stuff. But this is probably the most complex ALTA survey that I have prepared. It's called the Fountain Oaks Plaza. It's a Kroger shopping center with down here. They've got this beautiful fountain. They call it the Fountain Square. They got this beautiful fountain area, and this 2-story brick and stucco building. It's got specialty shops, restaurants, fitness clubs, and there's other buildings like that. I mean, this is probably a 60 or $80 million piece of property. And it's got a fuel island up here. It's got a bunch of stuff going on with it. There are all kinds of ALTA requirements for, they wanted, I believe it's item 9 in table A, that's got parking space requirements, building measurements, building heights. All those things are, here we identified the high point of the roof is 56 feet high. And there's a stairwell right next to it. This is where it comes into the Kroger. Of course, then there's some shops up in here, attached on the other side of the Kroger. There's several different tax parcels. This has been cobbled together by a whole bunch of different acquisitions over the years. There's a landlocked piece that our stormwater detention pond dumps into that I don't know why the previous owner of the shopping center property wanted to keep that. It's just a hole in the ground. Got some encroachments up here. They built between the first and second survey that we did. This was all under construction the first time. The second time we came back, this concrete was finished. They simply added some concrete to a BP station there on the corner and poured concrete over the wall or over the line. We've got this crosshatched area. Sometimes you have to do this. This crosshatched area up here is easement number 2 in a bioretention area per exceptions 24 and 26. So how would I make that stand out? We shade our pavement so that you can identify where it's paved and where it's not. And so we had to do something cross hatching. Sometimes it's just single hatches. We have a lighter cross-hatched area that is an access easement where the city of Sandy Springs can come from Roswell Road through here to get to the parking lot. Don't know why they would need that. I think it has something to do with this biodetention area, but I don't really know. There's a underground power easement that parallels Roswell Road that does not have a width on it. It's exception 21. There's a MARTA bus stop that comes right up to the property line. They did a good job. Whoever Marta hired you to put it right on the right of way line. We had to show, parking striping, so we've got all these stripings, which we did take from low altitude photography. We did not go out there and play in Roswell Road. Um, Oddly enough, to this day, the record point of commencement is where Long Island Drive, 50-foot right of way, intersects with Roswell Road, except there's this long recognized partial fillet where this curve intersects, and the pins are there. Pins have been there the last three surveys going back 25 years. But the point of commencement is this undocumented point of intersection of the right of ways if extended. And you see that a lot in old legal descriptions and old properties and subdivisions, especially where it's rounded intersections. You have a where it's rounded, we call that a fillet, or where it's squared off like a 45, that is a miter intersection. And a lot of times, for whatever reason, they will use the point of intersection if extended in quotes or in parentheses. So, this is just want to show you that don't be intimidated by them. This is probably the most complex and one of the most costly ALTA surveys that I have produced, and it's still not anything just to be petrified of. I had put in 9 particular survey notes to address my findings and their table A items. I have some other stuff over here, other notes. Here's the as survey description doesn't wind up being all that bad actually, which is kind of interesting. And they wanted all the insured legal descriptions on the survey, which I sort of detest. So we just snipped them and stuck them in there. There were 26 total title exceptions. The first 10 were standard, or they were leases. At least they were not survey matters. They may have been leases, they may have been options to buy. If it doesn't affect the boundary of the property in a permanent way, we're not concerned about it. And there's also a right-of-way take up here on West Belle Isle Road. We had to track that down and tie into it, make sure that we got it right. It's a fun survey, but just showing you that to know that it's even the more complex ones are not that intimidating if you just approach them very carefully. I can tell you that there are, let's say if you look at all the surveys done in the state of Georgia, ALTA surveys probably make up less than 2%. I can also tell you that somewhat for state board complaints, but more so for damage claims and lawsuits against surveyors, ALTA surveys probably make up a third of them. So it's very disproportionate. So probably one reason why a lot of surveyors will not do ALTA surveys, they tend to have a higher liability threshold. In other words, a higher likelihood that you're going to get sued. So that's unfortunate. That's it for working through an ALTA survey. They're not impossible. You just have to pay attention to what you're doing. Sometimes you have to back up and read things 3 or 4 times, but just apply everything that you've learned in your coursework up to this point. And yeah, I think you'll be just fine. I'll get an assignment out tomorrow, actually. That'll be our final assignment. I'll give some instructions and all on that. And thank you very much.